I've addressed pretrial. I've brought you over. I'm going to give you a moment if you want to share something else with me, but that's what I needed to address. So
I understand, and I'm grateful for your time. I had previously sent you a letter, and it has not been uploaded, but it was made an announcement to the courtroom during my pretrial that you do have it, and I was wondering why and if it will be uploaded, because I have another copy of it that I would like to hand deliver to you today.
I don't know why it has not been uploaded. I'll have to talk to my JA about that. If you want to give me another copy, that's fine.
Yes, please.
All right, go ahead and just tender it to one of the deputies. And actually, any objection if I just have the clerks scan it here in open court?
Yes, please. And do I normally get a copy? I haven't gotten one. I'm sorry.
Well, it'll be filed in the case.
You can just upload it, Judge. I can make a copy and give it to her.
Okay, all right,
Yes, please. If that would be okay, I would like to have that one uploaded. It's revised.
okay. And what I had directed my judicial assistant was to disclose this to the attorneys. The original, you've covered a great deal of ground that we've covered in open court on multiple occasions about the method and manner of communication. Having read the original letter, I did not believe there was any additional action that I needed to take, which is why I didn't take any action on that letter. All right? So to be filed, Ms. Boone will be returned to the Orange County Jail pending further order of the court.
Thank you.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Because I got this.
Sarah.
Regular us.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you string on me.
Sarah. Breathe, Sarah.
Yeah. You should probably shut up.
Sarah. Sarah.
My services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone. Derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone, especially in a murder case.
clearly your working relationship with Mr. Banquets was such that it deteriorated to the point where the two of y'all just couldn't work together to defend your case. So I'm not going to try to referee how that played out, why that unfolded the way it did. But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. You have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use their professional judgment and experience and look at the evidence, look at the law, and do the best they can. Also, you've got court-appointed counsel. As I've explained to you before, court-appointed counsel rarely have the luxury of representing one person and only having one case to focus on. I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations. You always have the right to retain a lawyer to represent you, and then that's between you and that lawyer. You can demand whatever expectations that you have as part of that agreement. But when it's a court-appointed lawyer, you have to accept and understand that they have other cases, other courtrooms, other responsibilities. And I'm cognizant of that when I'm addressing these types of issues about communication. So that's just food for thought, nothing to do today. I don't need a response from you. I just wanted to make sure you were aware of that and were thinking about that as we proceeded forward. So again, the court minutes reflect that I'm court continuing pretrial. I have granted a motion to withdraw. I have appointed Mr. Hobson to represent the defendant, and I'm taking no action on the motion, the ex parte motion for cost directed where GAC is responding. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Thank you, Judge.
All right.
I'm not able to say anything.
I'm doing my best to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope, is to hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.
I swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Welcome back, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10-10-77.
All right. In this case, you were most recently represented by Mr. Bankowitz. I granted a motion to withdraw. We appointed Mr. Hobson, and we set a status hearing today. Mr. Hobson, where do you stand as far as entering the case, and how much work do you think you have to get done to get the case ready for trial?
Let me start. I'll start at the back end, Judge. I would ask the court to set a status for sometime in January. I've had discussions with Ms. Booth before today. And she's okay with that, and I think that would make sense. I've got like a banker's box and a half of stuff I'm trying to wade through, plus the media stuff. So I think that would be the best option we've got right now, as far as I'm concerned.
So I don't have my dates, other than my pretrial and trial dates for next year. I don't have the calendar ironed out.
Okay.
But what I could do is just give y'all a January pretrial date, understanding that you're not representing that you're actually going to be ready to announce trial. But at least it's a next point to see how far you've gone, how much further you have to go. My hope would be in January, you'd be able to give the court a realistic estimate of when you would be ready to announce trial.
Yes, sir.
State, are you okay if we handle it that way?
Yes, that sounds reasonable.
I have a January 16th pretrial date. Is that far enough into January, Mr. Hobson?
Yes, sir.
All right, here's what we'll do. We will set pretrial conference on January 16th, trial period January 29th. The one thing I'm going to ask Mr. Hobson is if there are particular problems with the discovery, getting up to speed, that you know about before the 16th, if you could bring those to the court's attention beforehand.
Yes.
So we can at least start working those problems as they arrive, that would be my request.
Very good.
All right,
I would also ask the judge, the court as a caveat to indicate that it's a pretrial conference / status conference.
sure. Have the court minutes reflect that I'm setting it for pretrial conference / status for the defense to advise the court how long before they are prepared for trial. I think speedy trial was waived long, long ago.
4 years on, Judge.
Okay, so I'm just going to court reset it for those dates.
Yes, sir.
Anything else I need to do on Ms. Boone's case today?
Nothing else, Your Honor.
All right, Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Yes,
you.
thank you, Judge.
All right,
That's all I have. Have a good-
Ms. Vega, are you ready on